everybody. This is Stephanie Bivens with Bivens and Associates, and we appreciate you joining us today. We're bringing an educational webinar to you entitled How to Avoid Probate, Preserving Your Legacy. Most people know something about probate, and if they know anything, they know they don't want their heirs to have to go through probate. So this discussion is going to focus on what you can do in setting up your estate plan during your lifetime so that those you care about are not going to end up going through a court probate proceeding to settle your estate later. And I'm really pleased to introduce you to attorney Hannah McGuire. She is an attorney practicing with our firm and will be our keynote presenter today. So Hannah, with that, I will let you take it away. One housekeeping note first. For those of you that are attending our webinar live, if you have questions as Hannah's going through our discussion today, please feel free to use the Q&A feature to submit your questions. We'll make sure we answer all of them either at the end or during the presentation as we go. So with that, Hannah, take it away.
Great, thank you. Okay, so as Stephanie mentioned, my name's Hannah McGuire. I'm an attorney here at Bivens and Associates. Today I'm going to be talking a little bit about how to avoid probate and preserve your legacy. So first, just a little bit of background about the firm. So we practice exclusively in estate planning and probate. So that includes drafting estate planning documents, dealing with post-death probate and trust administration, some business entity formation, elder law, special needs planning, guardianships and conservatorships, and long-term care planning. So our firm has been around for over 19 years and has received the awards listed here. So when we talk about probate, let's start by doing a little background about what is probate. So this word gets thrown around a lot, and I think it's best to just, start with what are we talking about when we talk about probate? So at a very broad, high level, probate is basically, we're just talking about the administration of a decedent's estate through the probate court, which is just a division of the Arizona Superior Court. So with that being said, at a very broad level, what does that look like? That means a personal representative, so just an individual who is representing the estate, is going to submit pleadings to the court and open what's called a probate to go ahead and collect the deceased individual's assets, pay off any creditors, and then ultimately distribute everything to the appropriate individual. So in the event that there's a will, distribute to the individuals named in the will, or distribute to the intestate heirs under those succession laws. So that's kind of the broad term we're talking about when we're talking about probate. It's just that process of going through court to collect up the assets of someone who's deceased. What are some of the disadvantages? Why are we talking about avoiding probate? Why do people want to avoid probate? So some of the disadvantages of probate is, the first thing is that a probate court is public record, which means you're having to give certain heightened notice requirements. So you have to notice anyone who's named in the will, and you have to give notice to heirs of the decedent. This can also come in that you might have to give notice to anyone who asks for it. If someone just appears and says, I want notice of anything related to the estate, you're required to give them notice under the whole probate. So that's one of the big disadvantages, is really the privacy, the lack of privacy of administering the estate. Of course, you have court costs and attorney's fees associated with a probate, which can be a big disadvantage, is, having to pay, all those fees out of the administration. And then, there can be delays, of course, and you have to wait to be appointed as personal representative before you can do anything or really communicate with anyone on behalf of the estate. So it can really just cause post-death administration to be delayed, and it can ultimately be more time consuming. So those are kind of the big things that we're thinking about when we're saying, why are you wanting to avoid probate at all? So one question we get asked a lot, does a will avoid probate? A lot of people are familiar with wills, right? The document, a will, who am I leaving to? That's often the one document people think of when they think of administering an estate, or during my lifetime, my estate planning, they think of a will. Does a will avoid probate? No, not necessarily. A will would be used to direct a probate about how your assets are distributed. So a will is still a useful document because it can still inform, your loved ones and the people who are administering your estate of how you want it to be distributed. But a will itself does not avoid probate. It's a document to be used as a tool in the probate. However, not every estate will necessarily require probate. So one situation where maybe you have a will and you don't need a probate would be in the case of a small estate affidavit. So for the rest of this, I'm going to go through a few options of how you can avoid probate. This first one is the small estate affidavit. So something that I referenced here about something that doesn't have to go through the court would be a small estate affidavit. So a small estate affidavit can only be used 30 days after an individual has died. Arizona law basically carves out this exception to probate, sort of, that allows you, if the decedent had less than $75,000 worth of assets, or $100,000 if there's real property, to pass assets via small estate affidavit and not open a probate. The people who will collect under the small estate affidavit are consistent with the will, if the deceased individual had a will, or the people who would have received as intestate heirs. So if you die intestate or without a will, then your heirs, which would be, oftentimes a surviving spouse, surviving children, and then so on and so forth, would collect under this small estate affidavit. It's basically, you execute a document signed by the individual collecting the estate, that basically you meet all the requirements required to collect under this, and that will give them the authority to go to the relevant institution, financial institution, and collect up any assets. Of course, it's hard to plan exactly how much assets we're going to have, how much we're going to spend in our lifetime. So as far as an estate planning tool, most people aren't really planning with the idea in mind of, would this be small estate affidavit? Would this be probate? Usually it's not a planning consideration. This is just an option post-death, really, for your loved ones to possibly collect and avoid probate as one option. The rest of the options are more things that you can do proactively during your lifetime to help your loved ones avoid probate. So the second option would be establishing a revocable trust during your lifetime, or joint lifetimes, like for a married couple. So a trust, Stephanie spoke about trusts in our webinar on Tuesday, trust versus wills a little bit, but to kind of revisit that, a properly funded trust will avoid probate. So what am I talking about when I say a properly funded trust? Because that sounds like a weird concept. A trust is just a document on its own, right? It's just a document where you're saying where you want everything to go. We're establishing, this document that you can, use during your lifetime. But in order for it to direct assets, they have to be titled to the trust or payable to the trust. Otherwise, the trust can't just go out and grab them, right? They have to be directed into the trust. So, and if they are, right, so let's use a bank account for an example. If you have a bank account that's titled to the trust, you never have to have a probate because it's owned by the trust and there's continuity of ownership. That's what ultimately makes it avoid probate. So what happens though if the trust isn't properly funded? If the trust isn't properly funded, you could still end up with a probate, which does unfortunately happen. So as an example, going back to a bank account, if we have a bank account that's valued at $125,000, it's left in the decedent's individual name, there's no pay on death beneficiary on it, and it's just in their individual name, even if though they had a trust, a probate would still be required to collect that account. So of course, a trust is this really useful method. And this is where it's really important to have good counsel as well when you're setting up a trust, who can give you funding instructions to make sure the trust works properly to avoid probate. Because I think that's probably most of the people we see are saying, I want a trust so that my loved ones can avoid probate. So, you know, that's one important consideration when setting up a trust. To continue on, like related to trust, what are some of the other benefits? So of course, you know, with avoiding probate, that's a post-death benefit, right? Is avoiding probate. But a trust is also a document that exists during your lifetime if you set one up. And it has a lot of other benefits. So something that a lot of people aren't considering when they're doing this is incapacity planning and protection. Like if during your lifetime, you're no longer able to manage your assets, something happens to you where you're not in a position to be in control of your assets anymore, then you've set up people, right, successor trustees who can step in if that's the case and manage the trust, protect those assets, and use those assets for your benefit. You can also use a trust as a really good tool to set up sub-trusts for contingent beneficiaries, or sorry, for your beneficiaries. So a lot of people, you know, want to make sure that they protect what they give their loved one. Let's use a child, for example. You want to make sure that whatever you leave your child is meant for them, right? That it's theirs and it's not going to be infringed upon if they get divorced or if there's a creditor who wants to collect against them. You can use your trust to set up sub-trusts to pass to your children where they get that creditor protection as a really useful option. We can also do a little bit more planning for pets. Pets come up a lot. We love our four-legged children. And, you know, we can set up even sub-trusts for pets to say, you know, this pocket of money goes to them to be managed by this person, and, you know, care provider to be this person. So you can do more planning for them in a trust as well. You can also do estate and gift tax planning. So, you know, of course, if that's a consideration, we want to make sure we're really thinking about that in advance and doing the best planning possible through a trust to get as much to your loved ones and to do the appropriate planning for that to make sure we maximize your outcome from your trust and minimize the tax burden on those. And then circling back to something I mentioned earlier, you also have increased privacy in administration. So there's lower notice requirements. The only people that have to really receive notice are beneficiaries that you've named in the trust to receive. That's who would get, you know, notices and then and be entitled to information about your trust. So, you know, certainly this comes up a lot if you ever are considering maybe disinheriting someone. You certainly want to consider using a trust versus a will or going through probate. And then, you know, That's not the only consideration though. A lot of us just value our privacy. I know I do. So it's a big consideration of who's going to be seeing this information and seeing what assets are coming into the estate after your death. All right, what's another option of something that can avoid probate? Another option is joint ownership. So when something is owned jointly, let's start by using a bank account as an example. A bank account with two people on it, me and Stephanie are on a bank account together. We own it jointly. If I were to die, the bank account is just solely owned by Stephanie. It's now her sole account. That's, joint ownership. When one owner is no longer there on accounts and things, it just automatically passes to the joint owners. The reason that can happen is they're, already an owner, no probate required. It doesn't need to be collected. They already have access to it and they're already an owner. There are some downsides though of owning things in joint as joint owners. So if you say, okay, I know I want everything to go to my two children, let me just add them on my bank account as joint owners. You're opening up that account or any assets that you're adding them on as joint owners to any of their creditors as well. So you kind of expose that asset to more creditors and to more risk sort of with that. Same with collateralization. So it's an asset that they could use as collateral on against debts and things like that, loans. So again, it's just exposed to more risk, if you will. You also lose step up in basis. So I'm going to talk about that a little bit more with our next slide, where I'm talking about joint ownership with real property. This is where it really comes up a lot. So let's talk about, because this is a little more tricky, is with real property, joint ownership can get a little more challenging. So with real property, you have a few different ways that you can own real property. You can own it as joint tenants, or you can own it as joint tenants with right of survivorship. If you just own property with someone as joint tenants, me and Stephanie own a home, we're 50-50 joint tenants. There's no language about right of survivorship. If I die, my share will likely go through probate, because if I own it individually, it's worth more than $100,000. It doesn't pass to her automatically. It would require a probate to go and collect my half of the property, and my half is not going to necessarily pass to Stephanie. My half is going to pass to my heirs or whoever I have in my will as how I want my estate distributed. So that's one important distinction, is if our intention was to be joint tenants with right of survivorship, it's really important to make sure if you're signing documents at a title company that you're seeing that with right of survivorship, because that's a really big difference. And we see people oftentimes post-death dealing with assets saying, oh, but we owned it together. And unfortunately, we have to say, Arizona law says you have to say with right of survivorship for it to pass to your other joint owners. Married couples have a little bit of a different option. They can own as community property with right of survivorship. That will pass to the surviving spouse and they'll be the sole owner. When I mention loss of step up in basis, this is really big with real property. So upon the death of an owner of real property, that property, let's say it's owned solely, gets a step up in basis, meaning that for the purpose of capital gains taxes, you no longer have to go back to when they purchased the property, what was the value then. You can go to what was the value on their date of death. For the purposes of capital gains, the property has been owned a really long time, or really any time at all with how the market changes. It could be it's very advantageous to get that step up in basis as of the date of death. if you are saying, okay, I own my house, that's my big asset, I want it to go to my one child. In order to just avoid probate or really any post-death proceedings, I'll add them to the property now, and I will just sign a new deed and add them on as a joint tenant with right of survivorship with me. You are going to lose that step up in basis, because when you die, they're already an owner, and so they don't get a step up in basis. The basis is the same, just back when you bought it. So that is one big thing to consider. So whenever people are talking about real property, and again, this is where you really want to get specific advice based on your situation from an experienced attorney who can say, advise you what is your best option if you're dealing with a real property situation, or however you want to, pass whatever it is that you have. But particularly with real property, it's important to be really careful and to, make sure you're speaking with an attorney, because obviously this does get pretty complicated. So I just say that to kind of raise the flag of, if this is something you're thinking about, these are kind of some of the things that should be going through your mind and that you can ultimately talk about with someone, to make sure you're doing the appropriate planning. All right, what's another way that probate can be avoided and that an asset avoids probate? Another option is beneficiary designations. So an account with a beneficiary designation, no matter what other planning you've done, right? Even if you have a trust, an account with a beneficiary designation is going to pass to the individuals named as beneficiaries without any probate or any other administration. The named beneficiaries just coordinate directly with that financial institution, for example, and they, fill out whatever forms. Usually they make you fill out forms to collect the account, and they transfer the account to themselves and they collect the account. We commonly see this with IRAs, retirement accounts, life insurance policies. When you're setting up those types of accounts, usually those financial institutions are asking you right away to name your beneficiaries on the account from the beginning. So, that's probably where, people most commonly see them. But there are different types of beneficiary designations. They can be added to different types of accounts. So for example, with a checking account or a savings account at a credit union, you should be able to add a pay on death beneficiary. On your, investment brokerage account, you could add a transfer on death beneficiary. So although when you're setting up an account there, they're not usually asking you to add a pay on death beneficiary. So most people probably don't have one on their checking savings account, things like that, if they're in their individual name, but it is something that can be added to those accounts. One thing to note about any beneficiary designation, and I'm going to talk about it in some different contexts as well, but with any beneficiary designation, one thing you want to be cautious of is making sure, or just considering, aligning it with your greater estate plan. And when I say that, what I mean is, if you, let's say, have a trust, and in your trust, everything's going 50-50 to 2 children. But then you have this IRA, and your IRA is passing via beneficiary designation. When you name a beneficiary on that account, let's say you just name your sister as 100% beneficiary on the IRA. Well, when you're doing your estate planning, if that's how you really want it, instead of 50-50 to your 2 kids, we should be acknowledging that in your other estate planning to make your intent very clear. Because what we don't want is for there to be confusion, and for people to start thinking, if your 2 wishes are conflicting between beneficiary designation and trust, for example, that it was incorrect, or that for some reason they should challenge anything that's been done with your planning. So it's always good to make sure that beneficiary designations are at least acknowledged in your other estate planning. It's very useful, especially if they're going to be different, to acknowledge how you're leaving certain accounts that might be just passing by beneficiary designation. As I mentioned, you can add beneficiary designations to different types of assets. So as an example, you can add a beneficiary designation to your car. Here in Arizona, at least, Arizona Department of Transportation, so ADOT, they have something called beneficiary designation form. It's filled out by the car owner during their lifetime and left with the title. And then it's only used after death by the beneficiary to go and collect the title at ADOT. It's very useful. We give them to our clients when we're doing estate planning with them, and direct them to this resource too. I know other states don't all have these, so if you are in another state, it's important to see what options exist in your state for something like this, because obviously cars are something that are so commonly in our individual name, and maybe not even for married couples. I see married couples all the time, and it's just whoever went to the dealership or whoever went to the DMV, that's whose name is on the title, which is perfectly normal, and we can totally deal with that. But this is an important tool to use as another type of beneficiary designation. Of course, circling back to real estate, beneficiary designations can, be used with real estate as well. So a beneficiary deed is what it's called, can be used for real property to name a beneficiary on real estate. So, if you have a house and you want to leave it to someone, you would complete a beneficiary deed, and then it has to be recorded in the county where the property is located prior to the grantor's death, otherwise be invalid. So, that's sort of how a beneficiary deed works. They can be revoked. They're only effective after death of the owner of the property. The one caution with beneficiary designations is it's really not ideal for property owned as joint tenants, because the more owners you get, it starts to get a lot more complicated. So your half would pass via, the beneficiary designation, or really if you want to leave to multiple people, usually a beneficiary deed is not your best estate planning tool in your toolbox to accomplish that. And again, this is where you want to talk to someone and get personalized advice, and say, explain how you want property or certain things to pass, so that we can make sure you're getting the best possible outcome that's closest to your intent possible. But it can get really tricky when you start getting more and more owners on a property, and then they can assign their portion and as the pieces of the pie get smaller and smaller, you get a lot more people involved. So it's much simpler to use other planning methods when passing real estate. So I think it looks like we have a couple of questions in the Q&A. So let me see.
Yeah, so Hannah, one of the first questions that came up, and I knew somebody was going to ask this because it's always one of the first questions we get asked, is for probate proceedings, how much are the court fees? And then also on average, how much are the attorney's fees?
Okay, good question. So the filing fee does change a little bit. It's adjusted from year to year. I think right now, oh man, when you get the cost for just the initial filing, I want to say is $275 right now, I think. I could be wrong on the exact number, but somewhere in that neighborhood. Of course, you're also going to want certified copies of your letters. So to get certified copies from the court, I think it's $30 a copy. So depending how many assets, you're adding that to each one that you get. And then as far as, the attorney's fees related to probate, I will say it can be quite a range depending on if it is contested for any reason or how long it goes on, how many assets need to be collected, things like that. But I would say, and Stephanie can correct me if I'm wrong, but I would say starting at probably 6,500 and going up from there depending on how much is needed in the case.
Yeah. So another great question, Hannah, and I do agree with your answer. Another great question is, how long does the court probate process take? Just the length of time on average, if you can comment on that.
Yeah, we usually estimate that if everything goes really smoothly, we will be at a minute on the lower end. I would say 6 months would be kind of the lower end. We've got the 4-month creditor period in there, then wrapping everything up, getting everything done. I would say a low estimate for a probate would be 6 months. Ideally, and the court doesn't want you to go beyond about 2 years. So hopefully not longer than 2 years. Although I will say it can happen, and we've seen it happen if there's particular reasons for delays.
Yeah. And if a probate is going to take more than 2 years, just so everybody is aware, the court does reach out to the personal representative or their attorney and requires you file a status report and explain why the probate needs to remain open more than 2 years. Otherwise, if you don't explain it, the court might just administratively close the probate proceeding on its own. So the court is wanting these things to get resolved in a timely fashion when possible. Another question I see, Hannah, is, does the ADOT beneficiary form avoid probate regardless of the car's value?
Good question. I believe the beneficiary designation form doesn't have any sort of restriction as far as card value. So if the owner is completing it during their lifetime and placing it with title, that shouldn't be necessarily a consideration by ADOT. Where you would run into issues of the value would be if you're filling out ADOT's version of the small estate affidavit that I mentioned. That's where car's value could come into play and create an issue for collecting the vehicle if there wasn't any beneficiary designation or other way to collect the vehicle. But a beneficiary designation form, ADOT does not restrict value of the vehicle.
Yeah. As I like to tell clients, if you have a car where the doors actually open up, it's a very valuable vehicle, we definitely want to use the ADOT form to avoid probate. Another question, Hannah, is for married couples, does real property basis step up after the death of the first spouse?
Good question. It depends. So if it's community property with right of survivorship, right, that option that I said that many married couples have and that they can have, ownership is just going to continue, right? So there is no step up of basis because they're just still the owner. There's no change of ownership there. If it was owned by one spouse solely and is passing to another spouse, that would be grounds for a step up in basis if it was passing ownership and there was no continuous ownership.
Yeah. And just to clarify, if a married couple can own real property either as joint tenants with right of survivorship or as community property with right of survivorship. When they own it as joint tenants with right of survivorship and one spouse dies, the surviving spouse only gets a step up in basis on the first deceased spouse's 50%, but they still take their purchase price as the basis on their 50%. if the couple does own it as community property with right of survivorship, I think, Hannah, you meant to say, and I might have misheard you. I believe they do get the full step up in basis on the whole property to the surviving spouse. But it's interesting for a lot of couples, they don't realize the tax distinction between the community property with right of survivorship and the joint tenancy with right of survivorship forms on the deeds. And so we sometimes see old properties where title companies clearly didn't have a tax conversation with a couple. And so we sometimes are changing the form of ownership for our clients. So that's something to look out for. Another great question, are wills and trusts used together? And when is that useful? So the answer is yes. But Hannah, you want to unpack that a little?
Sure, yeah. So they are used together. So anytime that someone executes a revocable trust, so a trust during their lifetime and they create it, we always want to execute a pour over will, as it's referred to, with every trust, which basically is kind of a catch-all to say, if I've missed anything, right? I gave those examples of what could cause a probate or things like that. If anything ends up outside of the trust, direct it to my trust, right? Through whatever means are possible. If there's just an asset floating out there on its own in your individual name with no other way to get collected, that will is going to be used to then collect up that asset, whether it's through probate or small estate affidavit, depending on what it is. If it has no other way to pass or to get into the trust, that's what we're going to use is the will, the pour over will, to get it over to the trust. So they are used together, and everyone who has a trust should also have a pour over will.
Yeah. And Hannah, I always joke with folks, when we say pour over will, that's intended to mean POUR and not POOR. So people understand it when we literally spell it for them.
Yeah.
Very broad question. I'll read it, but I'm going to say my answer is it depends, and it's a case-by-case recommendation that married couples should make with their attorneys. But here's the question. So Hannah, you can unpack it a little bit more. What options make sense for a husband and wife estate planning, more specifically, use of a will, a trust, or joint ownership?
Okay, so one, I'm gonna of course, Stephanie is very right. It depends. But what does it depend on? These are some things that Stephanie mentioned in her last webinar, which I'll kind of highlight as some of the considerations when you're deciding what is the best path for you are going to be. What assets are there, right? So we always want to consider, are we dealing with real property? Are we dealing with bank accounts? Like what's out there? We would definitely want to consider what the assets are. We always want to consider your lifetime planning as well. What things, like I mentioned, the benefit of having a trust, and one thing that, I'm always going to recommend to people, as far as a trust goes, is if anything were to happen to you, you've kind of got this protective bubble of your trust, right? Where someone else can take over and, manage those assets for you and kind of protect the assets from you in a way, right? If you're no longer able to manage them. So that's, one thing you want to consider as well is your lifetime planning. And then, of course, other considerations that are specific to you. I think it depends a lot on your family structure. Are you maybe a blended family? Let's say you each have children from prior marriages, or do you all have children together? where do you want to leave things? Is everything going to charity? So of course your wishes are a big consideration as well, in addition to, you know, the assets themselves, and then doing lifetime planning too. There's rarely a situation where I say a trust isn't useful. So that is one thing I will note on that as well. Mainly for the reasons that I mentioned. But again, I think those are some of the things to be considering and discussing, you know, specifically with an attorney, so they can give you specific, personalized advice for that.
Great answer, Hannah. So we have another question, and this is a really good question, because I think a lot of times people get confused between how a trust and a pour-over will work together, even though they are separate legal documents. So the question is, you know, how are the pour-over will and not funding the trust different? So I think it's really the question is more, if you don't have your trust fully funded,
right,
how is the pour-over will going to work then?
okay, all right, so we see this sometimes, and so I'll kind of lay out what happens, and I'm just going to use the assumption that there's more than $75,000 of cash assets in my example. I'm going to rule out using small estate affidavits for this answer. So let's say you've set up your trust, okay, and you put your property, so your home, which is often done by the drafting attorney, your home is in the trust. But that's the only thing that ever made it over to the trust, right? Everything else, your brokerage account, your bank accounts, your cars, you know, all your other assets ended up just in your individual name, okay? And no beneficiary designations are on them. So they need a home, right? They're just sitting out there in your individual name, and your, you know, trustee who's trying to administer your estate is saying, okay, I know there's these assets out here, they're not under the trust. So what happens then? Your pour over will, so POUR, over will is going to be used to probate those assets. There will be a probate that's opened, and the probate will be used, a personal representative named in that pour over will open a probate, collect all those assets into an estate account. So they sell the cars, collect those monies, collect up your bank accounts, your brokerage accounts. They get all the money, simplifying it a bit, into an estate account. And then they get through the probate period. They've done the 4-month waiting period. And then at the end, all those assets that are in that estate account are going to go over into a trust account, going to become titled to the trust. And then they're going to get distributed according to the distribution provisions that are in your trust, right? So if ultimately your trust is directing that they go 50-50 to 2 kids, once they've been collected into the probate through the estate and then gone over to the trust, then they're going to get administered 50-50 to your 2 kids via your trust. So ultimately, we're getting to the same outcome, right? Like we're still going to distribute to the same beneficiaries in the same way. We're having more stops along the way, including a probate, which is what a lot of people want to avoid.
Great answer, Hannah. So if anybody has any more questions, go ahead and feel free to use that Q&A feature to submit some more questions. I think you can answer a few general questions that I get asked a lot, Hannah, which is who will handle your estate? You know, what do you call those people under a will versus under a trust? I know there's a lot of terminology confusion out there, so maybe if you can clarify that.
Good question. So with the trust, There's always a trustee during your lifetime. You're likely going to be your own trustee. After your death, you are going to name successor trustees to administer your trust. So, a loved one, or in some people's cases, maybe they're naming a third party licensed fiduciary. So, a neutral third party to administer the estate. You will name whoever you would like to administer your trust as successor trustee when you do your planning. With a will is only effective upon your death, so no one's administering your will during your lifetime or anything. But if the will goes, and is administered, when it is administered after your death, a person called a personal representative is appointed, often nicknamed PR, is a term that people will use in this industry. The personal representative is whoever you've either named in your will or who, has right of appointment as an intestate succession. So you will name someone, and again, it can be a loved one, or it could be a licensed fiduciary or bank and trust company who could serve as that personal representative role.
Yeah. And Hannah, just quick note for the audience, for people who are used to hearing the term executor or executrix, those are the same as a personal representative under a will. The older term executor refers to a man doing the same job. Executrix refers to a woman doing the same job. So for anybody who wondered what happened to those people, nothing. We just use the gender neutral term personal representative here in Arizona.
Exactly. I know every time I talk about personal representatives, I say sometimes known as an executor, but.
Right. Let's see. We have had another question pop in here. All right. Hannah, any parting words for our live attendees today? Pearls of wisdom, anything?
Pearls of wisdom. I kept saying it, but I think one thing is to just note that your estate planning is kind of personal to everyone. So it can be hard sometimes to give generalized advice. And so to get your best advice, I think going to an attorney with knowledge and experience is probably the best thing you can do to make sure you're doing your best planning and putting your loved ones in a position of where hopefully it's as easy as it can be for them to deal with this aspect of your post-death situation. So I think that's one big thing. And yeah, other than that, I really appreciate you guys taking the time to be here today. And I'm here at the firm, and if you ever want to schedule a time to talk with me, we do free estate planning consultations for 1 hour. So if you ever want to schedule a time for that, we're happy to be a resource for you.
Great. And also, if you think somebody else would benefit, or you just want to re-listen to this information, I know it's a lot of information to take in all at one time. We will be posting this webinar video online probably sometime next week on the firm's YouTube channel, as well as all of the other webinars that we are hosting. This is the third webinar we've hosted this week. And then next month, we are going to do another series of 3 webinars as well. So stay connected with the firm, follow us on social media, check out our Instagram, YouTube, LinkedIn, Facebook pages, and contact us if you want to sign up for our e-newsletter. We do a lot of educational events. In our experience, when families have the right information, they can make better decisions and have better outcomes for everybody involved. And that's always our goal. So thank you very much for attending. We appreciate your time, and we will see you on our next webinar.
Thank you.